Welcome. My name is Michael Frumkin, and I'm the organizer of this University of Miami Law School seminar series on the constitutional crisis. Our topic today is impoundments and other fiscal control strategies. And we are very, very fortunate to have Professor Zachary Price, one of the leading U.S. authorities on the subject, to speak to us today. Zachary Price holds the wonderfully named Eucalyptus Foundation Endowed Chair at UC Law in San Francisco. His work ranges from constitutional law and administrative law to criminal and civil law enforcement. His recent scholarly work focuses on constitutional questions generated by current political polarization. That's our subject. His book, Constitutional Symmetry, Judging in a Divided Republic, was published in 2024. His scholarly articles have been published in a large number of law reviews, including the Stanford Law Review, the Georgetown Law Journal Online, the Georgia Law Review, the Texas Law Review, twice, if I count right, on the Vanderbilt Law Review, and the New York University Law Review Online. He's contributed to a bunch of well-known publications, such as the Wall Street Journal, the Washington Post, SCOTUS blog, Notice and Comment, Administrative and Regulatory News, Law and Liberty, Balkanization, and the Supreme Court of California blog, and the Take Care blog. In fall 2023, Professor Price was a Bruce Fellowship at the Stanford Constitutional Law Center. Before entering teaching, Professor Price served for 3 years as an attorney in the U.S. Justice Department Office of Legal Counsel. He's worked as a litigator in private practice and clerked for 3 different courts: Judge Catherine Blake of the U.S. District Court of the District of Maryland, Judge David Tatel of the U.S. Court, or is it Tatel? I'm never sure, he'll tell me, of the U.S. Court of Appeals for the District of Columbia Circuit, and Justice Anthony Kennedy of the U.S. Supreme Court. Professor Price graduated from the Harvard Law School magna cum laude and from Stanford University with honors and distinction. Between college and law school, he studied philosophy as a Fulbright scholar at the University of Copenhagen, and he also worked for a member of Congress. We are really delighted to welcome Professor Price to our seminar series. I'm going to put myself on mute, turn it over to him. I understand there's slides, so brace yourselves.
Yeah, well, thanks so much for the generous introduction, and thanks for having me. Thanks to all of you for being here. So I do have slides. As I know as your norm, I'm going to try to talk for about an hour, but I think what I have is about right, but may have to adjust. So let me see if I can share the slides. Is that working? Okay. All right. Thanks. Okay. So what I'm planning to do, as you see here, is I'm going to try to just introduce the topic with the current issues, but then try to walk through some of the historical background and then talk about the current legal framework, and then dig into a couple of the current issues, walk through the legal questions and sort of say something about where we are. So in terms of, the topicality, you're all aware of this. The Trump administration came in and tried to assert control to an unusual degree over spending. It paused a lot of spending at the outset, and then in the Doge period, put USAID in the wood chipper, canceled a lot of foreign grant money, among other things, and then, started going after universities, paused grants and so forth. And then now we're in this shutdown as Democrats are fighting ostensibly to get these Affordable Care Act subsidies, but I think frustration with a lot of this spending behavior and the weak congressional response is obviously part of the background. So this is in the news. You're probably aware of this. But I think an important question here is what's really different about Trump, as we can talk more about later. As I'm sure you've talked about before, we've had a significant trajectory towards stronger executive governance for some time, I think driven mainly by the political context of the country, the polarization and partisanship that encourages presidents to try to deliver a partisan agenda through executive action. At the same time, it sort of weakens Congress by compounding the collective action problems in Congress, making it hard to enact legislation. So Congress tends to be weak in pushing back. Presidents have incentives to act in aggressive ways. So we've seen this across many areas, across recent administrations. But I think the push into spending, and in particular to declining to spend appropriated funds, is sort of new. with Trump. There he is. So, you looked at my essay with two co-authors that tried to describe this a little bit, provide some analysis, and suggest we've got something new here in terms of the degree of unilateral centralized executive disruption in federal spending, this broad assertion of unilateral authority. And, we said this is sort of an escalation even compared to what other presidents have done in this area, very broad unilateral action and kind of covering the full range of spending from the initial issuance of grants to how they're administered to uh, you know the appropriations process. So a real effort across the board to get stronger control over the money that's going out from the federal government and inject executive policies, put an executive stamp on the spending, even if the underlying statutes don't necessarily provide for that. So I think that's the context. That's why it's an important issue. As I also talk about, I think it's significant in terms of checks and balances because, as you're probably also aware, presidents have a lot of authority these days. The Congress over time has conferred a lot of power on executive agencies, on the president, both domestically and in foreign affairs. There's been a kind of longstanding policy choice that goes with trying to have a more powerful, effective federal government. But in that context, I think the appropriations process is really important because the executive branch can often set policy or at least take the initiative in key areas. And then, but where Congress pushes back is through its annual appropriations. That's where it can impose limits, can exercise leverage, redirect efforts. So it's a real important feature of checks and balances. And if the executive branch is going to weaken that constraint, then I think it is another significant step towards this sort of executive governance being the way the federal government works. So that's the context. But I want to kind of now go back and sort of talk about some of the history because I think it's interesting in its own light, but also maybe gives some context in terms of where we are. So I'll try to walk through this relatively quickly, but then kind of bring us up to the current legal framework, and then with that in place, we can talk more in a more concrete way about some of the current issues. Okay, so first of all, the constitutional background. What does the Constitution actually say about spending? So it says a couple of things. There's, first of all, the Appropriations Clause, which says no money shall be drawn from the Treasury, but in consequence of appropriations made by law. So what that means is you can't spend money, you can't spend public funds unless you have an appropriation, which is a statute specifically providing authority for the expenditure. Also relevant, though it applies much more broadly, is the Take Care Clause or the Faithful Execution Clause. This says that the president shall take care that the laws be faithfully executed. That has a number of implications, but I think one of the things it does is it rejects the idea that presidents have what historically was called a suspending power or dispensing power. Those were prerogatives exercised by English monarchs at certain periods. There was the power to, just decide that a law shouldn't apply or wouldn't have force. Take Care Clause says that's not the way our system works. The president has a responsibility to carry out the laws faithfully, give them effect. So with respect to spending, that should mean, if there's a statute that says you have to expend funds on some activity or effectuate some policy or give out grants, benefits, what have you, that's something the president has to carry out, even if he doesn't particularly like it. A third provision is for the Army Appropriations Clause. The Constitution actually says that you can't have an appropriation lasting for more than 2 years. And this draws off background I'll talk more about in a second, but as you probably know, the framers had an anxiety about standing armies coming out of the English background. And so this was meant to make clear that you couldn't have an army that would be indefinitely funded. There always needs to be need to come back to Congress for appropriations. This has been applied pretty weakly. As I'll explain in a second, annual appropriations, not just for the Army, but for all sorts of things, are really central to how the system has come to work. But as you might imagine, when you're trying to build the F-35 or something like that, that takes a decade, you've got to sometimes have longer range planning. So, it's sort of a weak constraint, but it is there in the Constitution, reflecting a general principle. Okay, so that's what the Constitution says. Now, here's James Madison, always looking serious as always here. But he said the Federalist Papers, talking about this power of the purse, he actually called the power of the purse the most complete and effectual weapon with which any constitution could arm the immediate representatives of the people for obtaining a redress of every grievance and for carrying into effect every just and salutary measure. So that's a really strong statement about the power of the purse. It reflects the way the framers thought of those provisions I was just talking about as really central features of legislative authority, being a really important constraint on the executive branch, a real important protection for popular liberty. And that's reflecting this English background. As you might know, England went through this period of turmoil in the 17th century, so about 100 years before the American Revolution. Parliament and the Crown went to war. The Parliament won. It executed the king, governed the country as a commonwealth for a while. Then they restored the monarch, and then they had more problems. So then they had this so-called Glorious Revolution in 1688, where Parliament invited the head of the Dutch Republic and his English wife to come and rule England as new monarchs, and in that context imposed various constitutional settlements. So a big issue throughout that whole conflict was control over money, particularly money for armies. And coming out of that period, Parliament maintained control over public funds and provided them only for limited periods at limited time, did various things to ensure that the crown. So as I was explaining, that there's this important historical background where Parliament comes into conflict over fiscal policy, doesn't want to provide taxes and revenue that the crown wants because it doesn't trust the crown. It becomes this military conflict. And in the eventual constitutional settlement, Parliament retains control in important ways over public spending, and in particular, it uses this mechanism of temporary appropriations to maintain a legislative check on crown policy. So that's all the kind of background, the kind of constitutional framework in which the founders think about these things. The same actually is true in the pre-revolutionary colonial period. The colonial governments generally have a royal governor and an elected legislature, and those elected legislatures try to maintain the same kind of control over public funding, and sometimes come into conflict with governors over that. So all that's to say that for the framers of the Constitution, it's just completely obvious that Congress should have this power of the purse, as it's called, this power over collecting taxes and then over how those resources are spent. I actually think they didn't think through some aspects of that relationship under the new structure. That's one of the things I go through in one of my articles. The president is supposed to have certain constitutional authorities. Elsewhere in that same Federalist paper, Madison talks about how you can use this power over funding to take power away from the executive. That makes a lot of sense in the British context, a little more complicated in the US context. But for the type of stuff we're talking about, I think it's pretty clear that the framers wanted Congress to have power over what money the government has available for activities like law enforcement, foreign aid, things like that. And so that sort of sets up the constitutional structure. Okay, so we get the Constitution explicitly giving this power of the purse to Congress. That's the historical background. Now, one of the things that Congress does is from the very beginning, it picks up that practice of the British Parliament of providing only time-limited appropriations most of the time, not always, but most of the time. So here's the very first appropriation statute, and it's providing funds only for the service of the present year. And this has generally been the way things work for a lot of important government functions. Congress provides appropriations in limited amounts for limited time periods. And it does that for the same reason that Parliament did. That way, it has an ongoing say in what's happening, it has leverage over the executive branch, and it can reassess what spending is appropriate or what activities are appropriate when the executive inevitably has to come back for more money. So that's an important practice that reinforces those constitutional authorities. But something that's important to appreciate is that the system actually didn't work terribly well for a lot of the country's history. And so I've been working on a paper that goes through that background and tries to think about it. And so I'm kind of summarizing the conclusions I've reached there. I can talk more about it. Uh, but an early example is so basically executive officials, they're bound by these appropriations, but they don't always abide by them. They move money around. They sometimes spend or commit to spend more than they have and then go to Congress afterwards. And so a really high profile example of this in the Washington administration is the response to the so-called Whiskey Rebellion. So this is what this image is. This is a sort of tax revolt in Western Pennsylvania. The federal government was imposing this excise tax on whiskey. Whiskey was a really important commodity in that area of the country, in some ways a kind of medium of exchange, because it enabled them to convert grain into something that they could ship and market, even in the kind of terrible transportation conditions. So it's really important to them, and they view this as sort of an abusive imposition by this remote government, sort of like what Britain had done to the colonies. So they're rebelling here. They're tarring and feathering a tax collector, and the Washington administration thinks we can't have this. We need a really forceful response because it's a kind of challenge to the authority of this new government we set up. And so, but they raised this giant militia force to suppress the rebellion, but Congress isn't in session and they don't have any money for a militia. So what they do is they transfer appropriated funds for the regular military, use them for this militia force. And then Washington comes to Congress afterwards and he says, look, I was fulfilling my oath. I swore to preserve, protect, and defend the Constitution. And, I took the action I felt was necessary, and I'm counting on you to approve of it if it was justified. If not, you can tell me. So he sort of staked his honor on Congress ratifying what he'd done after the fact, and they did. They appropriated new money, ratified everything he'd done. So that's an example of this type of action. But in some ways, it's kind of becomes a fairly routine aspect of governance in the 19th century. People call it the coercive deficiency. Agencies will spend or obligate funds beyond their appropriations and then come to Congress afterwards and say, hey, here's what we did. If you agree it was justified, can you give us more money? And so it's a deficiency. They spent more than they had, but people in Congress had felt it was coercive because, at that point, the government had committed to doing things or spending money or even entered contracts with people, and they didn't want to stiff them. So they sort of felt like they had to go along. So people in Congress often complain about this. There's this particularly acerbic guy who's all over this guy, John Randolph from Virginia, he's a part of the Jeffersonian Party, but um, sort of belongs to a faction that concludes the people like Jefferson and Madison are squishes. He's sort of a particularly strong Republican, but he's got a very biting wit, and so he has this famous quote where he says, "Those who disperse the money in the executive branch are like a saucy boy who knows his grandfather will gratify him and overruns the sum allowed him at pleasure. As to appropriations, I have no faith in them. We have seen that so long as there's money in the treasury, there's no defense against its expenditure." So this is back in, I believe this is from 1806. He's complaining about this emerging practice. He's saying, agencies act like the presumptuous grandson who just knows they can do whatever, and the grandfather will let them get away with it, provide the money. But there's not a great solution. So there's these kind of long running back and forth between Congress and the executive branch over this type of thing. Lots of debates about it, kind of ebbs and flows. But this is part of the way governance works in the 19th century. So I think you shouldn't make too much out of it in a contemporary perspective, because it kind of fits with other features of the environment at the time. One is there's just a lot of practical difficulty with budgeting, moving money around. Money is really different. I mean, at first there's not even paper currency until the Civil War period. Money is complicated. Communication is complicated. You've got people out in like remote parts of the country doing things, and they have to make choices about what they need to do. So there are a lot of practical explanations. Um, and also, the administrative law structure is pretty different. Officials often take action and then may be held liable in court, but then go to Congress and ask for an indemnity. So if you're like the customs collector, the way administrative law works is you might go and seize some property to collect some customs duty. The owner might sue you for trespass. They'd say, "Hey, you stole my property. You had no right to do this." The collector would say, "I acted in accordance with the law, with my legal authority." And then a court would adjudicate that. But then if the person was held liable, they'd be personally liable, but Congress often passed private bills to indemnify people if it felt what they'd done was justified, even if it was overzealous or technically unlawful. So it's an environment where executive officials, for both practical and legal reasons, are often kind of taking initiative and then coming to Congress afterwards. And I think the spending behavior sort of fits in that context. But as we move into the kind of modern administrative period, we get a series of reforms that I think really change how things work, eliminate those sorts of practices. So one important thing is the Anti-Deficiency Act. So this is enacted in 1870, amended in 1884, and other times criminal penalties are added in 1905. I'll talk more about that later. It tries to outlaw that practice of coercive deficiencies. It doesn't work terribly well until you get some other reforms starting in 1921. This is under President Harding. There he is. But it had been kind of something people have been pushing for throughout the progressive era. There's this kind of mania for accounting and budgeting during this period. There's this article I found from like 1911 or something that said, the sun of the lawyer is setting and the sun of the accountant is rising. So fortunately for you, I'm not sure that that has quite happened. I think lawyers are still have more influence than accountants. But the thing was, a government at all levels before this period, as I was just describing, like accounting standards aren't great. There's often not great clarity about what's happening. And people think of kind of rationalized budgeting, which they pick up from things happening with big corporations. They start applying them to government, saying there's a way of kind of maintaining accountability. It's important for democracy to know what money is going to what. So this kind of wave of reforms happening at the state and local level, and it culminates at the federal level in this major statute in 1921. And one thing to say is it's there's also a period in which particularly the federal level, but also other levels of government, executive power is expanding. People, particularly progressives in this era, they think that executive officials can better represent the overall public interest. And they also just think having a kind of powerful, effective administration requires presidential leadership. So there's also a period when you get presidents asserting powers of removal. You probably encountered the uh, uh, famous removal case by Chief Justice Taft that is from the same period. So it's in this context we get this budget reform, and so it sort of fits that model of presidential power in that the main thing it does is it says, okay, the president from now on needs to every year submit a unified budget for the executive branch. Before this point, agencies would submit their own estimates to Congress, and it would often be kind of subject specific congressional committees that would look at them. So there's a lot of kind of connections between people in Congress on particular committees and agencies. And that's part of how this relationship of overspending and then having it made up, all that works. So this 1921 reform says we're going to have the president take control over all those submissions, create a unified kind of rational budget. So we have, someone is more accountable for what the executive branch wants. It establishes an agency called the Budget Bureau to help the president with that task. The Budget Bureau, through a series of reorganizations over time, becomes today's Office of Management and Budget. So the Budget Bureau initially is in the Treasury Department, but the directly accountable to the president. Eventually, now it's kind of part of the White House, the executive office of the president. So it does those things that enhance presidential power, but it also establishes the Comptroller General and the what's now called the Government Accountability Office, which we really call the General Accounting Office, kind of in line with that mania for accounting I was describing. But this is a congressional officer who's going to be able to audit executive accounts, impose checks in various ways, and then it consolidates control over appropriations in appropriations committees in the House and Senate. So, I interpret all this all as it's often seen as a big win for presidential power, but I think it also helps make Congress's power of the purse more effective because it gives kind of unified, more reliable estimates to Congress, and also gives Congress certain tools for policing what's going on, maintaining stronger control. And this gets kind of reinforced in practice. Both President Harding, the first Budget Bureau director, the first Comptroller General, they all take this law really seriously, try to be really get stronger control over executive spending. FDR actually does some things to try to limit deficiencies. And then we get some more reforms in 1950 that require apportionment, so kind of spreading money out over the fiscal year and maintain you're going to have enough for the full year, and that both disciplines agencies, but also some people think makes Congress make sure it's providing enough money to get through the whole year in a realistic way. So we get at that point what's sometimes called this kind of classical budgeting period. It's kind of mid-century, 1960s, 1950s. We've got these powerful congressional agencies. You've got budgeting working in this kind of incremental, iterative way. So agencies generally are not overspending the way they had in the past. We finally got a pretty effective congressional control at the same time that we're getting pretty powerful executive agencies developing. So I think that's a really important kind of implicit interbranch bargain as we're building up this federal administrative state. We're also getting a more effective check in Congress through this appropriations process. So then the next kind of moving pretty quickly here, then we get a different kind of challenge, the so-called imperial presidency, Lyndon Johnson, and particularly Richard Nixon, they kind of do the reverse. They start trying to not spend money when they don't think it's necessary. Nixon, in particular, there he is, right? He asserts a constitutional prerogative to impound funds. So impound just means taking money as appropriated and not spending it. I'm actually not sure of the historical origin of the term, but that's all impoundment means. And so it's something presidents had done at times in the past, usually with some statutory authority or at least some ambiguity about what appropriations laws required. Nixon just says, in Article 2, I have the power to not spend money if I don't want to. But lawyers in his own branch don't really buy this. The future Chief Justice William Rehnquist is at the Justice Department's Office of Legal Counsel. He writes an opinion saying this doesn't make any sense, right? The Constitution requires faithful execution of the law. That's antithetical to saying you don't have to spend money if Congress requires it. Courts reject this. They back off the constitutional argument. The Supreme Court upholds the mandatory character of certain spending without addressing any constitutional issue. So, Justice Scalia has an opinion. It was actually a dissent in this line item veto act case, decades down the road. But he referred to Nixon as the Mahatma Gandhi of impounders. I don't quite know what the Gandhi analogy is, but it's clearly meant to mean he's like the most passionate, committed impounder. But he says the Supreme Court proved him wrong in that case where the court upheld a spending obligation. So Nixon backs off, and then he gets impeached, right, and all that. But we get the Congress after Watergate. So actually, Nixon's still president when this happens, but he's in hot water. So we get this 1974 reform, which tries to dial back some of that presidential budgeting. It establishes a congressional budget process with budget committees. Some question about how well that works. But it's an important feature of the process now. Now the president proposes a budget, but then Congress is supposed to come up with its own budget. Generally, more or less ignores what the president proposed. But these days, sometimes it doesn't do the budget at all. Anyway, there are a lot of complexities there, but it's at least an effort to kind of make Congress more central in the initial proposals as well as the ultimate enforcement of spending requirements and limits. But also, more importantly, perhaps for our purposes, that 1974 law includes a section that's known as the Impoundment Control Act that tries to make clear that the president can't impound funds in the way that Nixon did. Okay, so there's more we could say about the history, but I think that gives us the basic building blocks for the framework that applies now. And the key thing is we've got these framework statutes that kind of come in the executive branch from both directions, both overspending and underspending. So on the overspending side, we've got that Anti-Deficiency Act, which was originally in 1870, beefed up over time. But these days tends to be taken really seriously within the executive branch. So it's kind of finally addressing the things that John Randolph was complaining about. So what does the Anti-Deficiency Act say? It says, it's kind of core provision. It says you can't obligate funds. You can't even commit to spending them unless you have a sufficient current appropriation. So obligate is a term of art, but it's a kind of committing in a formal way to spending money. You can't enter a contract. You can't promise funds in a determinate way unless you've got an existing appropriation that gives you authority to do that. So that's the core of the Anti-Deficiency Act. It also bars the government from accepting so-called voluntary services. This is a confusing provision because it sounds like you can't volunteer for the government, which, I mean, that's literally what it says, but it's actually understood to mean that you can't take voluntary services from someone who might then be expecting as a result to get paid. Because sort of like with the coercive deficiencies, agencies would sometimes have people volunteer to work extra hours or without pay, but then they come to Congress afterwards asking for that, to get wages for that. And that would sort of defeat the operation of the Anti-Efficiency Act if you could kind of engage in extra work and then come and ask for money. So this provision was added in 1884 to kind of plug that gap. And then we've got their mechanisms for you're supposed to report any violations. The Comptroller General is also supposed to report violations to Congress. Comptroller General investigates violations. And people who break the law are subject to personal penalties if they violate it willfully. That's a criminal offense. Okay, so that's the Anti-Efficiency Act. So that keeps agencies from overspending, from committing money that they don't have. Excuse me. It's also the reason why the government shuts down the way it does right now. That the government shuts down when annual appropriations run out because the Anti-Deficiency Act has been understood to mean people can't work in that circumstance. So why is that? It's because if an employee comes to work, as part of their job, then the agency is obligating funds because it's going to need to pay them in exchange for their work. So it's violating that core provision, and you can't get around it by asking them to volunteer in the interim in hopes of getting paid later because of the voluntary services provision. Now, the voluntary services provision has an exception. It says you can accept voluntary services for emergencies involving the safety of human life or the protection of property. So this is the source of what gets talked about in the press as essential workers. It's not really that they're essential in some abstract sense. The idea is that you can accept voluntary services if the person is performing some function that relates to the safety of human life or the protection of property. So that's been understood pretty broadly to cover things like air traffic controllers, keep the planes flying safely, prison guards, a lot of law enforcement functions. So that's why. So those people, they can provide voluntary services, so they can be asked to work, even though they're not actually paid until the new appropriations come in. Okay, so that's the Anti-Efficiency Act. On the other side of things, we've got the Impoundment Control Act I mentioned earlier, which was Congress's response to Nixon's assertion of an executive non-spending authority. So this law, it kind of defines or addresses two types of impoundments. The first are what are called deferrals. And so a deferral is like a delay in the spending. And as the statute stands now, there have been some amendments we can talk about, but basically it says you can't defer money beyond the end of the fiscal year, and you can only do it to provide for contingencies, to achieve savings made possible by or through changes in requirements or greater efficiency of operations, or when specifically provided by law. So it basically says you can only defer money if it's consistent with the policy reflected in the spending law. You can do it for sort of good faith administrative reasons, or because there's been some change in circumstances. You can't defer money based on policy disagreement with the spending. So that's tough break for Nixon. It has been understood to allow something called a programmatic delay. So deferrals, the president is supposed to report them to Congress. Both the executive branch and the Comptroller General have said if you have a programmatic delay, so if you're kind of just pausing money while you figure out how to administer it, they say that's not a deferral at all. It doesn't implicate the statute. Probably that should be a deferral. It's just it's a lawful deferral. But anyway, that sort of deferral has been allowed. The key thing is you're not supposed to defer money based on policy disagreement. Then if you want to cancel the spending altogether, so not just delay it, but just say, hey, we don't want to spend this money, that's what the statute refers to as a rescission. And the law allows the president to propose rescinding funds, and then Congress would consider that proposal under special rules with no filibuster, with this sort of 45-day time period. And if Congress rescinds the money, then it's gone, it's canceled. So, but they have to pass new legislation, basically canceling the money. If they don't do that, then the statute says the president then has to make the money available for obligation. So has to, spend it despite having proposed rescinding it. It also, the statute says that the deferral provision does not apply to funds subject to a rescission proposal. So effectively, that means you can propose the rescission. Congress will think about it for 45 days. During that period, you can pause the money. You don't have to spend it. But then if Congress doesn't enact a rescission within the 45 days, then you've got to go back to obligating it before the fiscal year ends. Okay, so that's the structure of the Impoundment Control Act. So let's get to some of our current issues. So a key figure in what the administration is doing, you probably heard of him, is Russell Vought, who is the head of the Office of Management and Budget. So this is the agency that started out as the Budget Bureau, but it's gotten moved into the White House, right, into the agencies directly controlled by the president. And Russell Vought and his general counsel, Mark Paoletta, are really committed to the idea that the executive branch needs more control over federal spending, and they're very good at what they do. They understand the laws and the structure of the budget very well. So they've been very effective in the ways they've been trying to pursue this objective. So here you might have seen this. Trump, put out this this very strange video where Russell Vought is like the Grim Reaper, but that's meant as a compliment, right? He's really good at killing off unnecessary spending or something. Anyway, so what are some issues here? So first of all, some of what they're doing probably counts as an impoundment. I mean, it's a little hard to tell sometimes, what even is going on or what the legal theory is. But as I said at the beginning, we've had a lot of pauses, delays in spending. At least some money seems not to have gotten spent in ways Congress intended. So Trump himself and certainly Mark Paoletta, when they were during the campaign, had, like Richard Nixon, had said the president should have a constitutional impoundment power. The administration hasn't, if you know this if you looked at my essay, but they haven't taken that position officially quite so directly, but they have done a lot of things that are hard to explain without it. I think, just like William Rehnquist, I think this is a misguided view of Article 2. The big problem is the take care clause. As Rehnquist said at OLC, the Constitution says the president has to faithfully execute Congress's laws, that you're not doing that if you're canceling money that's supposed to be spent. And then the Impoundment Control Act, I view as it also, the way it interacts with annual appropriations is somewhat ambiguous, but I think that the idea of it was to make clear that there's no kind of general impoundment authority belonging to presidents. So to the extent in the past those kind of default rules were unclear, presidents could say, well, I didn't know this was mandatory. Now they can't. The only way you can cancel money is through that rescission mechanism. So generally when Congress appropriates funds, the default understanding is spending them to accomplish the policy goals in the statute is obligatory. And then, what Vought and Paoletta point to is, historical practice, but I think that also doesn't support this interpretation. I think if you look at the examples, presidents were very rarely asserting a full-on constitutional prerogative. They're generally making arguments about the statutes. And in any case, the ground rules were somewhat ambiguous, but Congress made clear that spending is generally obligatory, the Impoundment Control Act, and since then, presidents have generally complied. So I don't think you can say that even the text points one way. There's historical practice establishing a prerogative. So to the extent that's going on, I think it's unlawful. It's not a valid theory of Article 2. and should be rejected. So that's one current issue, kind of in the background. Okay, so let me hit. I think I'm doing okay on time, so let me hit a couple more. Just briefly. So on the other hand, another thing the administration has done is to actually use the rescission mechanism in the Empowerment and Control Act. And this is completely fine from a legal perspective. So this, I think I have the headlines here. Yeah. So there were some rescissions under President Reagan, I believe, maybe a couple since then, but it had been sort of dormant. But the Trump administration made a rescission proposal to Congress for about $9.5 billion, included some foreign aid, but also the money for NPR, PBS, and Congress approved it. So they're those fast track rules for considering these things, and in particular, there's no Senate filibuster, so you only need a simple majority. So they made this proposal. Congress actually made some adjustments. In particular, it took out from the rescission certain foreign aid money for HIV control efforts, but then it approved the rest. So as a legal matter, that's fine. I mean, that's what the Empowerment Control Act calls for. There is a political issue in that it's a way of circumventing the filibuster rule, which normally applies to those annual appropriations. So to get, at least under current Senate rules, to get annual spending, you need 60 votes in the Senate, which normally means you need some degree of bipartisan support. But then to rescind the money, you only need a simple majority. So some Democrats in Congress complained, look, we agreed to this overall package. That's how you got in the first place. Now you're coming in and nixing the parts we don't like. So that is very likely to further complicate an already somewhat dysfunctional budget process, because people are the way you get bipartisan support is through a degree of log rolling, combining different priorities, getting things that people can live with. If they have to worry about you coming back and canceling certain parts with a simple majority, maybe they'll be less willing to agree to it in the first place. So there are practical problems, but as a legal matter, this is the way that things are supposed to work under the Impoundment Control Act. Okay, so good. Impoundments without congressional action, not lawful in my view. Big constitutional innovation to be concerned about. Proposing a rescission through Congress, that is what you're supposed to do, so may raise other problems, but it's not unlawful. Then you have this thing called pocket rescissions. That is something that I believe, at least, as a deliberate tactic, is something that Vogt and Paoletta came up with. They tried it in the first. So actually, Vogt and Paoletta both had their current jobs towards the end of the first Trump administration. They were at OMB as well, and they actually tried this pocket rescission technique, but people in Congress got mad, pushed back, they backed off. But on their way out the door, they issued this letter to Congress that kind of laid out some of their legal theories, including this one. So the idea of the pocket rescission is to use that 45-day delay that I talked about when you make a rescission proposal to actually kind of cancel money. So the idea is you remember, the president makes the rescission proposal, and then Congress has 45 days to act on it. During that period, you can pause the spending. So the idea of the pocket rescission is you make your proposal less than 45 days before the fiscal year ends, and then you pause the spending, and then the fiscal year ends in the interims, and then the budget authority is gone. So you effectively cancel the money without Congress acting. You've sort of flipped the default. So a pocket rescission, got the pocket image. You're probably it's an analogy to the pocket veto. So in the Constitution, if a bill goes to the president, if it's normally the president has to act within a certain period. If he doesn't, if in other words, if he doesn't sign or veto the law within, I'm embarrassingly blanking on the time period. I think it's something like 10 days. Then the bill becomes law anyway. But if Congress recesses in the interim, then that doesn't happen. So the president in that circumstance can kill a bill by just putting it in his pocket, by not acting on it. So that's the analogy here. Anyway, so they did this with about $4 billion in foreign aid at the end of the fiscal year ended October 1st. That's why we're in the shutdown. So they made a proposal like this. I think the Impoundment Control Act should not be read this way. It actually doesn't say quite that directly that you make the rescission proposal and you can automatically pause for 45 days. What it says is that you make the proposal, Congress considers it under those special rules, and then it says you have to make the money available for obligation unless Congress enacts the proposal within the 45-day period. And then it says the deferral limitations do not apply to money subject to a rescission proposal. So it's at the very least ambiguous, but I think that the emphasis is on ensuring the money gets obligated unless Congress enacts a rescission proposal. And if you've jammed Congress in a way that they can't act within the 45 days, then you haven't really respected that limit. And it's also the only way you end up in this position is by arguably deferring money unlawfully, because remember, you're not supposed to even delay the money based on policy disagreement. You're supposed to kind of spend it prudently over the course of the fiscal year. So the only way you can have a big pile of money left over at the end of the fiscal year, this is the point Philip Wallach makes in the piece I think you also read. You can end up in a position to make a meaningful pocket rescission only if you've sort of unlawfully deferred money in the first place. So it just generally kind of turns the statute on its head. It treats a law meant to limit impoundments as kind of creating this mechanism for unilateral cancellation of spending. So I think it's an unfortunate development. And this takes us into one of the recent Supreme Court emergency rulings, though, because the folks tried to challenge this in court, and they brought a suit under the Administrative Procedure Act and said, "Hey, you're supposed to be spending this money." District Court agreed, said you've got to spend this money before it expires at the end of the fiscal year. This pocket rescission thing is nonsense. It went up to the Supreme Court, and they basically said you can't. There's no private right of action to enforce that requirement of the Impoundment Control Act. Impoundment Control Act allows the Comptroller General to sue if under the statute on the Impoundment Control Act, budget authority is required to be made available for obligation. Is not made available for obligation, then the Comptroller General can sue. And so, the court's ruling is very terse and a bit opaque, but seems to be saying that this authority of the Comptroller General to sue, it precludes private suits. So the Comptroller General would have to bring a lawsuit to challenge a pocket rescission. Now, it should be said, there's a very easy way for Congress to repudiate this practice if it wants to. In the past, when this has happened, not quite so deliberately, but there have been occasions in the past when there were rescission proposals that ended up being considered past the end of the fiscal year. One of those instances, Congress just, in the next annual appropriations, it just extended the budget authority into the new year to make clear that it didn't like what the executive branch is doing. So there's the Comptroller General remedy. There's the Congress has tools of its own, but according to the Supreme Court, you can't get at this problem with private lawsuits. Okay, so pocket rescissions, I think they're unlawful, not a good development, but according to the Supreme Court, we have to rely on these kind of political remedies rather than fast-paced private challenges. Okay, let me just talk about very quickly one more thing, and then go back to kind of the big picture. So another thing that's come up is that when people have brought court cases challenging non-spending, in particular challenging termination of grants or non-payment under grants. So we have all these agencies that give out a lot of money to private parties, whether it's researchers at universities or NGOs or what have you. This has become an important way in which policy gets carried out. And so when the Trump administration started not honoring those grants or canceling them, people brought lawsuits. And the administration has argued you can't bring these cases under the Administrative Procedure Act in ordinary federal district courts. They belong in this specialized non-Article III court called the Court of Federal Claims because of this old law called the Tucker Act. So the Tucker Act says that the Court of Federal Claims has jurisdiction over damages suits when they're based on a, quote, express or implied contract with the United States or a statute or constitutional provision that mandates payment of money, so-called money mandating statute. So it gives that court jurisdiction over those types of suits. The Administrative Procedure Act, which is the normal mechanism for challenging executive actions in federal court, it generally provides jurisdiction to challenge final agency action, but it only permits remedies other than money damages. It doesn't provide a damages remedy, and it also doesn't apply if some other statute expressly or impliedly forbids the relief. So there's some complexity here, but as I understand it, it's generally been understood that the CFC has exclusive jurisdiction over claims for contract damages, at least if they're over $10,000. So, I mean, that is a previously established point. On the other hand, you can't have APA suits that result in payment of money because in a Supreme Court case from several decades ago, the court said if you're invalidating agency action and some kind of payment follows from that, then that's fine. That's not damages. That's just a consequence of the ruling the court reached. So anyway, this issue has come up to the Supreme Court again in these emergency rulings in both Department of Education versus California and then the more recent NIH versus American Public Health Association case. And where we've ended up, those of you shared in its entirety only by Justice Barrett, is that challenges to grant terminations and non-payments count as breach of contract claims that have to go in the Court of Federal Claims, but you can challenge overall policy, guidance documents, that sort of thing in federal district courts under the APA. So it kind of splits the claims. But the key thing is if you're trying to get paid under a grant that you're saying was unlawfully canceled or not properly performed, it looks like you've got to take that to the Court of Federal Claims. So what should we make of that? I think it's at the very least debatable. Courts had said before that the key to a contract is having consideration, right? I mean, you know this from 1L year, right? The problem with treating a grant as a contract is, there are lots of government contracts, and some of the stuff that falls in these cases may, fit that pretty conventionally. But at least some prior cases that thought, well, if there's a grant, there's not really consideration. You're just kind of, the government's giving money to achieve kind of generalized public benefits. It's not like it's buying an aircraft carrier or something. So courts in the past had understood more narrowly what counted as a contract under the Tucker Act. So, but the Supreme Court, again, with very limited reasoning, came out the other way. So what should we make of that as a practical matter? I think it, as people have pointed out, as the dissents point out, it creates a lot of practical problems. If you're someone getting a grant, you're conducting research or something, you're going to stop unless you have other money. If you can't get immediate relief, going over to the Court of Claims and litigating for a while and eventually get damages, may help, but it's not going to, it doesn't directly address the unlawful termination of activities that Congress was seemingly wanted to have funded. So it creates a lot of practical problems from that point of view. I do think it has some potential advantages. It kind of slows things down, lets these things get hashed out in a more deliberative way. And there's another issue in these cases, which is kind of going back to the Pago rescission thing. What happens when the fiscal year ends? If you've got an APA suit and the fiscal year ends, then is the case then moot, right? Because the money's gone. There are lower court cases that say not necessarily. The Supreme Court in that case about the Comptroller General Authority, it seemed to assume that they do disappear. But in any event, the Court of Claims avoids that problem, so far as I can tell, because those judgments are paid out of a permanent appropriation. They don't depend on annual appropriations. So going down that route could ensure there's eventually a remedy. There's a vehicle in which courts can get at some of these executive power questions, and maybe we get out of these kind of high stakes interbranch battles. So I think there are some possible benefits there in terms of maintaining some legal accountability from courts, but there are also big downsides as well. Okay, so let me just close. I know I'm going on quite a while here. Hopefully this is all right. But the big picture context here with all these things, and this this is not original thought. Other people point this out. Is a lot of the law in this area has not been litigated very much, and that's partly because Congress was assertive about defending itself, understood this was an important congressional authority, and so understandings are worked out about how the law worked, partly with that background in mind. And in fact, as I was just alluding to, dealing with these things in court can be very challenging. You've got huge amounts of money potentially. You've got essentially administrative judgments about who to give a grant to, how to administer it, and so forth. Very fast time frames. There are a lot of reasons why they're hard things for courts to come to grip with. The system works a lot better when it's really Congress pushing back, exercising leverage to get the government to do the things it wants. And so why isn't that working? I mean, so this, I think, fits into the broader picture I started with of the ways in which polarization and partisan division has ended up encouraging unilateral executive action, but also weakening Congress. So this is a little out of date right now, but it's good graph showing the way we've had this kind of polarization and sorting. The parties, since about the 1970s, since that point when they passed the Impoundment Control Act, our political system has gotten organized around much more distinct, ideologically defined political parties that have less overlap in views among their voters, and that produces in Congress much more polarized voting. This is a measure some political scientists came up with that basically tracks how often people in the House or Senate are voting with members of their party and in opposition to members of the other party. And as you can see, it was very high in the Gilded Age, the period after the Civil War, and then it went way down in that period I was describing of kind of classical budgeting. There were other problems in that period. There's the period of kind of Jim Crow segregation, among other things, but it's also the period of the New Deal. It's the period when the parties are not terribly ideologically distinct, but that might be part of the reason that the budget process was working pretty well during that period. But anyway, since then we've had this trajectory of polarization, and so as it's described in a classic article, these days we tend to have separation of parties, not powers. And that, when the president does something unilateral, that's a blow to Congress's institutional authority. But the president's co-partisans in Congress have more an interest in advancing their party than in defending their branch's institutional interests. So that's a dynamic we've seen in a lot of other areas. I think we're seeing it now with spending in a big way. But this is an area where courts aren't really the best forum for pushing back. So I think we have to hope that Congress will revitalize itself at some point, push back against some of this. Otherwise, I think these patterns are likely to stick around and get used by future presidents as well. So let me just stop there. Thanks. I hope that was helpful, what you're looking for. We're looking forward to discussion. But that's all I have in terms of lecture.
Well, thank you so much for that wonderful and informative discussion. We'll take a 10-second break, and then we'll come right back to our discussion.